A startling revelation: millions of Americans on the move are unknowingly putting their estate plans at risk. It's a common oversight, but one with potentially devastating consequences. Did you know that only a small fraction, a mere 24%, of Americans have a will? And even more concerning, nearly a quarter of those with estate plans haven't updated their documents since they were first drawn up. This is a critical issue, especially when you consider that state laws governing inheritance, healthcare directives, and powers of attorney can vary significantly. But here's where it gets controversial. Legal documents like wills are generally valid across states, but the practical implications of state-specific laws can be far-reaching. For instance, differences in laws can impact income tax, state estate tax, and even marital property rights, potentially undermining the efficiency and fairness of your estate plan. Tasha Dickinson, a trusts and estates lawyer, puts it plainly: documents that might be relied on in a time of need are creatures of state statute. In other words, the nuances of state laws can have a significant impact on the enforceability of your estate planning documents. So, do you need to start from scratch with a whole new set of documents? Experts say no, but a review by a lawyer in your new state is highly recommended. Dickinson advises updating ancillary documents like powers of attorney to ensure they align with the laws of your new state. Let's delve into some specific examples to illustrate the importance of this. Property. The distinction between community property states and non-community property states is crucial. In community property states, both spouses have equal ownership rights to all income, assets, and debts acquired during the marriage. When one spouse passes away, the surviving spouse automatically inherits the other half. This can result in a full step-up in value for a jointly owned house, eliminating capital gains tax if sold immediately. However, in non-community property states, any property or debt acquired during the marriage is owned by the spouse who obtained it and can be left to anyone they choose. If a house is jointly owned, the surviving spouse inherits only the deceased spouse's half, which may not receive a full step-up in value. Powers of attorney and advance directives. While your documents should remain valid, states often have their own statutory forms and specific requirements. As Dickinson points out, in a time of need, you wouldn't want family members and medical professionals arguing over the authority of an unfamiliar, out-of-state document. Executor of will. Your will should remain valid across states, but states may have their own rules on who can serve as the executor. For example, if you move to Florida and name a non-Florida resident as executor, that person must be a relative or risk disqualification. As Dickinson warns, if you haven't named anyone else who qualifies, it could create a significant problem. These are just a few examples of the potential pitfalls that can arise when estate planning documents aren't updated to reflect the laws of your new state. It's a complex issue, and one that deserves careful consideration. So, what do you think? Are you ready to take control of your estate planning and ensure your wishes are respected, no matter where life takes you? We'd love to hear your thoughts and experiences in the comments below.